First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and ye shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Welcome to the first DCA. As I understand the calendar today, we have two cases. The first case being Kellenberger versus Walmart Stores East. And Mr. Sprague, are you prepared to go forward?
Yes, Your Honor.
All right. Any time for rebuttal?
3 minutes, Your Honor.
Okay. So noted for the record. Please proceed.
May it please the court. Your Honor, reversal is required in this case because the trial court erroneously limited cross-examination of a key defense witness and then refused to allow a proffer on the issues in question. There are three substantive parts to this argument, which I will go through with the court. But before I do so, I want to review the law as it exists in the state of Florida regarding proffers, because it affects everything that I'm about to say.
Well, and before you get there, Mr. Sprague, I do have some questions. I have some questions about the purported impeachment of your client with the request for production. And I want to make sure I understand that part of this. As I understand it, the Walmart attorney used your client's responses to a request for production in trying to impeach him at trial?
That is correct, Your Honor.
And those responses, as the court understands it, as I understand it, were actually signed by counsel and not by your client, correct?
That is correct, Your Honor, as they would be under the rules of civil procedure. Only interrogatories are verified by clients.
And these were not interrogatories, these were responses to a request for production.
That is correct, Your Honor.
And this was not sworn testimony from your client.
That is also correct, Your Honor.
Are you familiar, Ms. Sprague, with any rule of procedure, any rule of evidence that allows counsel to utilize responses to requests for production as impeachment?
Your Honor, I am not aware of any, and indeed, that's one of the points that we make in our papers, which I was going to get to second, but since Your Honor brought it up, I'll deal with it now. There's a substantive difference between bringing in the substance of his work and his ability to work, and whether or not he still was able to enjoy work, versus asking questions about documents that were and were not produced during discovery. They did the latter, not the former. There's no rule of civil procedure, no case that I'm aware of that allows them to essentially take a discovery dispute that should have been resolved in front of the court on a motion to compel and try it in front of the jury.
So just to finish the court's thought, were the requests for production or responses listed as exhibits, trial exhibits?
Your Honor, to be completely frank with the court, I am not 100% certain. I do not believe that they were.
And you mentioned motions to compel. As I understand the record, there was not a motion to compel responses to that request for production.
Right, and that was one of the points that we made both in the trial court and in this court.
And these were objections that were made to these requests by counsel?
Yes, they were phrased a little oddly. In answering the request for production, stated that we were not making a claim for lost wages, and then stated that there were no documents in our possession.
And it's a little hard from looking at the record, Mr. Sprague, looking at the transcript, I should say, we don't have a video. So all I see is counsel from Walmart asking the court if she can approach your client. So I take it she approached your client with the responses to requests for production,
Yes, Your Honor.
and then proceeded to ask him questions about the responses to the requests for production.
That is correct, Your Honor.
And in the midst of this, there were multiple sidebars.
That's right.
But ultimately, even after being admonished by the court, counsel for Walmart went back and asked more questions about the responses to requests for production.
That's right, Your Honor. And I would draw the court's attention to the Rowland case, which we cite in our papers, because the Rowland case really deals with this. In that case, like in the instant case, counsel never used the word fraud. They never explicitly accused our client of lying. But the repeated questions about documents that were or were not produced implicitly raised that issue. And the court, like in Rowland, in the court in this case, drew attention to it in front of the jury with multiple sidebars and overruling objections, making the matter even worse. And that's something that the Rowland court specifically pointed out in reversing on similar grounds.
Well, and that was my next question. How did this infect the jury's deliberations in this case?
Well, Your Honor, I think it's important to bear in mind that this is a contested liability slip and fall case in which, in closing argument, the defense called into question the veracity of our client's version of how the fall occurred. So credibility of our client was an issue that has affected both liability and damages. It's not just an issue that went to damages. When you essentially imply that evidence is being hidden in front of a jury, it prejudices the jury's mind against that person in all phases of the trial. And so, there was direct attacks on our client's credibility, and then so this issue goes both to liability and damages. In that credibility was a distinct issue in both phases of the case.
You concede you opened the door.
Your Honor, I would put it this way. I think that we opened the door to substantive questions about his work. I think they could have asked him, do you continue to work? How many hours do you continue to work? Do you continue to work for the same clients?
I mean, that's a slippery slope a bit because you did not raise an earnings loss claim.
Correct.
And everybody kept talking about, we understand there's no wage loss claim, but you asked questions about and elicited testimony that he could no longer work, and certainly work in the capacity he was working before or for his business. After that occurred, there were multiple sidebars. And wasn't there a discussion about let's limit the cross-examination as opposed to a curative instruction to the jury? And second part of that question would be, did you not have an opportunity in closing to address the issue again?
Your Honor, as to the first part of the question, I believe that the judge ultimately said, look, you're walking very close to the line, referring to defense counsel on this issue, but then did not cut off the cross-examination. As to the second issue, I think that it would have been more detrimental than beneficial to our client to draw continuing attention to this issue when we had been implicitly accused of withholding evidence. And so I don't think that the opportunity to address it either in redirect or in closing argument would have cured the prejudice.
Counsel, let me, following up on the same line of discussion that Judge Jay raised, did you preserve, both below and in your briefing, did you preserve the argument that there's a procedural impropriety in using discovery responses to impeach a witness in his testimony, as opposed to, I mean, the discussion as I read it was mostly about, are we or are we not talking about whether he ever made money for his family and whether he had any documentation to prove it when he talked about, I'm not a man, I can't provide for my family. It was more of a substantive discussion about money. Was there a specific objection to the use of discovery as impeachment? And was that preserved on appeal?
I think that there are two answers to that question, Judge Kelsey. As far as the procedural side of that, whether or not as a matter of procedure it was allowable, I don't believe that that argument was specifically made. But we did argue and continue to argue that it is improper to drag discovery disputes and discovery materials, which should be a court issue, in front of the jury.
And Judge Kelsey's point's a good one. I do remember in one of the sidebars some discussion, and perhaps it was Mr. Ahmed, talking about Walmart was also disparaging counsel, which would suggest that there was some intimation that counsel's response to these requests for production was a feature of this. Is that also an argument that was made below and is being made in front of us here?
Your Honor, I believe that was an issue below, and it is all part and parcel of the argument that we make based on Emerson and Rowland. When you are talking about the production or non-production of documents during discovery, it's both the client and the counsel, which again affects all areas of the case, and the prejudice that after that really can't be cured. I am ready to move on to a different topic unless the court has more questions about the issue with the cross-examination on the discovery issue.
I do have a question in another area, Ms. Sprague, and I understand we're getting dangerously close to your 3 minutes, but as to the manager's testimony and limiting cross-examination of the Walmart manager, I guess former Walmart manager, related to the special needs employee, just so I understand your argument is that the manager was saying that this employee was malleable, was willing to answer in a way that would accommodate the questioner, and all you were trying to do on cross-examination is to say you aren't disputing what she said related to the leak from the roof. Did I fairly synopsize that?
Very, very close, Your Honor. What Ms. Smith did during her direct is by using the surveillance video. And if you'll recall, Ms. Cruz had testified that this leak occurs every time it rains, both before and after the accident, and that a trash can would be drug into the area to catch the water. Well, on the surveillance video, a trash can is seen being drug into Action Alley, which is a different part of the store. And what Ms. Smith testified to is, no, that's Action Alley, see the trash can, and it's for an AC condensation issue. So she implied that this testimony that was given about the trash can, that Ms. Cruz was just confused about the area of the store that it applied to, which was compounded by the testimony about Ms. Cruz being a special needs individual. So but the second part is exactly correct, Your Honor. All we wanted to do was confirm that her testimony wasn't that Jamie Cruz was confused. We weren't asking her to opine as to her mental ability. We weren't asking her to opine as to her cognition. We didn't ask her, for instance, in your opinion, is she capable of remembering events? If you look at the specific question in the transcript, it is just to confirm you are not telling this jury, and then to paraphrase that Ms. Cruz is confused. That's a different question. All we were asking was for her to clarify her testimony on direct. So time is quick upon me, but I want to make the point about proffer because I believe that it is really important, especially as it relates to the work order. We weren't able to ask questions of Ms. Smith regarding Ms. Cruz. We weren't able to proffer questions about the work order and the issue of this other roof repair and what it applied to. We weren't able to ask questions about Mr. Thaxton and his testimony. And that prevents this court from doing a full and effective appellate review. When the trial court said, stop wasting the court's time, we're not going to have a proffer, this court essentially lost its ability, for instance, to determine whether the work order applies to the area of the fall or some other area, or whether it was proper impeachment. And under the case law, we cite this court's O'Shea opinion, among others. This court can't speculate as to what the answers to those questions would have been. This court can't assume that they would have been beneficial to Walmart. The court can't make really any factual determinations in the lack of data. All the appellate court really can do when the court refuses to grant a proffer is send it back for retrial and let it be thrashed out properly as it should be in the first place. The last thing I want to point out on this issue is that the defense
Mr. Sprague, not to advise you, but you've only got a minute left for rebuttal. Or is this the 12 or is this the 15, Madam Clerk? The 15? So you only have a minute left.
Then, Your Honor, I'm going to sit down.
And I did ask you questions into the 3 minutes, so I will give you another minute. So we would show 2 minutes for the appellant. I will give 2 extra minutes if Walmart wants to utilize those 2 extra minutes. So on rebuttal, you'll have 2 minutes, Mr. Sprague.
Thank you, Your Honor.
Thank you.
Please proceed.
Thank you very much. Good afternoon. May it please the court. Good afternoon, Mr. Sprague. My name is Scott Cole, and I'm here on behalf of Walmart. And Judge Hay, I just want to address your initial line of questioning to Mr. Sprague. I would respectfully disagree with the court that on a couple of the facts that the court presented, or the couple of the facts the court said in his questions to Mr. Sprague. First, the Walmart trial counsel did not approach the witness with a request to produce. So that did not happen, at least in the pages 794 to 810 of the transcript.
Well, I see the counsel asked to approach the witness. Do you see that, Mr. Cole? That's why I was asking.
What page is that, Your Honor? I did not read that, and if I missed it, then I apologize to the court. I have the pages here, and I just looked at them when you were asking Mr. Sprague.
And I've got the relevant portions of the transcript.
Judge, and if it is there and I'm mistaken, I would like to continue and say that doesn't matter for a couple of reasons.
So here's 807.
Yes, sir.
It says, if I can approach, the witness says in the next page. So I assume counsel is approaching the witness. I don't know why counsel would be approaching the witness unless there was some reason to show the witness up.
Well, we don't know why, but I don't believe that counsel approached with a request for production. In fact, the words request for production were never used. And the reason why this issue is not reversible error is for the...
Well, let me stop you, Mr. Cole.
Yes,
If
sir.
I'm just looking at the transcript, again, I want to be correct about this. She's reading from something, counsel is reading from something, and she is saying to the witness, it says income earned. After she's asked the court to approach the witness, she says it says income earned, and then questions, so you did not provide any evidence.
Right, and he says that's the driver's license on the front, income earned. And it says you did not, and you're not going to ask there was no request for production saying, to my knowledge, and I wasn't there, I don't know, there was no camera, but to my knowledge, she did not approach with a request to produce. She's talking about his driver's license, which would not be typically in a request to produce. And then she asked him about income earned, because that wasn't the answer. It didn't say no income earned. The answer was they objected to the question. So I do not believe in...
Well, I mean, that aside.
That aside.
It appears she approached with something, and something.
Correct. But I don't believe she approached with a request to produce. And I think it's important to point out a couple things here why this issue should not merit a reversal. First, as Mr. Sprague admitted in his discussion with the court, we never accused Mr. Kellenberger of lying. We never accused Mr. Kellenberger of fraud. We never accused him of hiding the ball. We never accused him. You did not follow up with discovery responses.
Well, all of this, though, you would agree, Mr. Cole, emanates from a discovery request.
I would agree with that he did not provide documents. But if you look at the colloquy of what occurred here.
No, and I've got it. I
Okay.
understand it. I've got it right in front of me, and I read it very carefully. I read it twice. There is a give and take based on the responses to requests for production, which I know we all know is a discovery vehicle. And there's a pseudo objection to at least the request asking for these financial documents, which sort of brings us into the legal realm. And that's this judge's point. Have we not injected a legal issue, superimpose that on a lay witness, and ask that lay witness a question that's better left to a lawyer?
And I would respectfully disagree for these reasons, and again, reiterate why it doesn't mandate a reversal. First, if you look at the questions that came before this, and we all know the background, as Judge Thomas pointed out, they opened the door to it. They didn't make a lost wage claim, they didn't make a loss of earning capacity claim, but they spent an inordinate amount of time talking about his work, talking about how it affected him, talking about how he's not a man anymore, he can't support his family. None of that was relevant to this trial. So we had a right to go into those things in cross-examination. And what...
And this judge agrees with it.
Right.
I agree with Judge Thomas.
And what happened then, and what happened right before this, around page 790 to 800 of the transcript, the trial counsel was saying, and you, sir, you were complaining that you're not a man anymore because you can't work, but in fact, you were working from 5 days a week to only 3 days a week. And he said, no, that's not true. I was working weekends. So he's now arguing about how much he works. So that then led the Walmart trial counsel to say, well, wait a second. When we asked you to provide any documentation, or if you had any documentation to show that you worked, he didn't have any. And I would...
But then he said, and it's right in the transcript, that I did give you something.
Bank
and then,
statements.
Correct. And then counsel, Ms. Morales, says back, no, you didn't. And so, but I think at its core is because this was a lawyer-answered request. I mean, would you not agree that that was something a little different than it should have been?
Yeah, I agree that it probably should not have gone into, but if you look at the questioning, and like you, Judge Hay, I have it right in front of me, he says, and I'm looking at page 801, I'm not a big record keeper. Trial counsel then says, and that brings up a good point. She asks him a question about, and when you have any documents to show that you're working, she's trying to say that he didn't have anything to support this claim that he was working, that it ruined his life, other than his own testimony. We were going to what he didn't have, not what he didn't produce. And she did use the words produce on a couple of times, but at the end of the first question, she says, that was something you don't have. The question was objected to. The second question was, and I'm on page 806 now after a sidebar, you didn't have any in your possession, again, talking about the same documents. And he says, I had bank statements. And then she says, and you didn't give them to us, did you? And he says, I didn't know that. That was the only question of those 5 questions that was ever answered. The third time she brought it up, you don't have any documents in your possession. So we're asking what he had to support his work, not what he was hiding, not that he was committing fraud, not that he was committing a discovery violation.
Don't you solve this by doing one of many things? So you could have sent a request for admissions and ask him if he had the documents or not. Likely you would have gotten an objection to that, and then you moved to compel. You could have sent an interrogatory asking for those where he answers under oath, but by using a request for production that has a pseudo objection to it, you have enveloped this process with a lawyer-answered discovery document, and that's this judge's concern right now, that has been injected into a trial, and you're asking these questions of a person that may be ill-equipped to answer those questions.
But the question, Your Honor, for why we believe it does not, and we strongly believe the case law supports this, it does not mandate a new trial, is because those questions, and as Mr. Sprague said, nobody accused him of fraud. Nobody accused him of hiding the ball. Nobody said he was improper in his discovery responses. Had we said, you have those documents and you hid them from us, or you had those documents and you didn't produce them to your lawyer to give to us, you had those documents and you objected and you didn't do anything with them, then I can understand the court may look at this differently. But we never said that. We repeatedly said they're not in your possession. And the point of the questioning were, they're not in your possession, except for the one about the bank statements we did ask about produce. They're not in your possession to support your claim that you're working 5 days a week.
Where does the transcript say that? They're not in your possession?
That's the way the questions are asked. The transcript, the first question says.
What page are you on?
801. But and this question was objected to, it was never answered. If you look at the end of the question, that was something you don't have. On to 802. Second question, 806, line 21. You said that you didn't have any in your possession. That's when he says the bank statements. We say we never got them, and he says, I didn't know that. Third question, 803. At the end of the question.
803?
I'm sorry, 807.
807.
Lines 18 and 19, no documentation, none in your possession, right? Then he says his wife's father died. So she says, no, that's respectfully, let's go back to the question.
Well, but look at the bottom of 807. The question is there was none. You did not produce any documentation to
Correct.
support.
Correct, and that question wasn't answered.
Well, I mean, that you would agree, Mr. Cole, that suggests that there was something there to produce. Why would you ask such a thing?
Well, it was, yes, that was the gist of that question. But the first two questions that she asked, that you didn't possess them, then she said you didn't produce them, and then the court approached, this is for the second sidebar, then the third time, in 810, she asked the question again about providing documents, and she withdrew the question. So the reason why, again, I'll reiterate why this does not mandate a reversal.
Well, let me ask you about that, too. On 810, when asked to provide documentation on that issue, yes, ma'am, there wasn't any provided.
Correct.
So, again, hiding the ball is the suggestion. How is that not the takeaway for the jury?
Because, Your Honor, for a couple reasons. Number one, the question wasn't answered, she withdrew the question. Okay, and then the court had another sidebar, and then it was never raised again. Number two, we never overtly said, as the case law has shown, you're hiding the ball, you're concealing things, you're not providing us with things. We never said that. We said he didn't provide us, and we said he didn't possess things, but he never answered that question except the bank statements, and he said, I didn't know that. Third reason is he opened the door to all of this. The fourth reason is that it didn't go to, this was questions about his damages. The jury never reached damages, and counsel was able to clean it up. And counsel did clean it up.
Mr. Cole, you're a smart lawyer, good appellate lawyer, and you would agree, though, there are certain situations where something can be so radioactive, even though it only goes to damages, it can affect liability.
Absolutely, and it could affect his credibility. Absolutely, I agree with Mr. Sprague on that.
But you're just saying not in this case.
Not in this case. And if you look at it, Judge, this was a 227-page examination, including all the sidebars. This occurred over 10 pages. It was, 1/20th of the examination. We never brought it up again with another witness. We never brought it up on closing argument. The issue was over with. So it was a series of questions over 10 pages. He answered one of them. That was it. The rest were objected to. There were sidebars. And it was never addressed at any other time in the trial. Had we brought it up on closing and said, you heard us ask Mr. Kellenberger if he had any support for this. He never gave it to us. He had it or he didn't have it or whatever, and argued that on closing, then I agree with the court. That would have been completely improper and may mandate reversal. On these facts, it simply doesn't. It was a small portion of the trial, unlike the case all cited by Mr. Sprague, the Dadeland case and the Emerson Electric case, and it just simply wasn't a big aspect of the trial. The court's read the transcript, obviously. Judge Hay, you read it more carefully than I did, about approaching the bench. And this case was about whether there was water on the floor in aisle N3 and the video. And
What about the proffer issue, Mr. Cole?
well, I respectfully disagree with Mr. Sprague. I think he mixed them up. He said the proffer issue went to the work order, and it didn't. The proffer issue went to Ms. Cruz's testimony. But we didn't want Ms. Cruz to testify at all because she's a special needs associate. We spent 4 days arguing over this in the trial court. The trial judge finally said, I'm going to let you read Ms. Cruz's deposition, then I'm going to let Ms. Smith, the manager, say 3 things about Ms. Cruz. Just a comment about her special needs and how they have to tell her multiple times to do certain tasks, and if there's issues that come up, her mother has to come in and help her. That's it. So that's what we asked on direct. They then come up and try and get in evidence that the trial judge specifically that said could not come in, and they asked Ms. Smith to comment on Mrs. Cruz's capacity to say where the leak was. Completely objectionable. So we objected. The judge said it's not coming in, number one, because it's a violation of my court order. Number two, because it's outside the scope of direct. Number three, because it's speculative. And by the way, the proffer issue is a non-issue because they never asked for the proffer. We asked for the proffer, and what would the proffer have told us? We know Ms. Smith would have said, and we probably should have let the question go and not objected, because Ms. Smith would have said, no, Ms. Cruz didn't know where that leak was. Ms. Cruz has the mind of a 5 to 7-year-old, which she was not allowed to say. Ms. Cruz has the special needs issues, which she was not allowed to say. And most importantly, Ms. Cruz answers yes to every question she's asked just to please the examiner. So not only did they not ask for a proffer, we did, and the judge said no to it. They didn't ask for it, but the proffer would have helped us. Proffer would have clearly helped Walmart, because we know Ms. Smith would have commented on Ms. Cruz's capacity or inability to know where this leak was. So that's a non-issue as far as I'm concerned, Your Honor. And with regard to the work order is another non-issue because they admitted, and again, respectfully to correct Mr. Sprague, if you look on page 1028 of the transcript, Ms. Smith, they specifically admitted to the trial judge, they're not saying that the work order was addressing leaks in N3 where Mr. Kellenberger fell. It was in another part of the toy department by the bicycles. So it had nothing to do with the issues in this case. The work order was simply not related to any issue. So none of those issues under the abuse of discretion standard mandate a reversal or a new trial in this case. Absolutely not. And I don't know if the court has any more questions for me. I just think the work order was in a different part of the store. The proffer, they didn't ask for it, and it would have helped us. And they tried to get in. They tried to ask Ms. Smith questions of what they specifically kept out over 4 days of argument. Then they tried to sneak one in that helped them. That's not appropriate. And then I think we've discussed the questioning of the document issue. And if the court has any more questions for me, I'll address those. I just simply feel that under the case law, Mr. Sprague's admissions here on oral arguments ends the issue. Certainly, you should not cross-examine someone on discovery. We agree with that. And certainly, you should not bring that up. But it was more akin to, and we did use the word provide or produce to us, but it was more akin to, you have nothing to support this claim that you're working 5 days a week as you say you are, and that you can no longer work because of this Walmart slip and fall. Nothing to support it but your own testimony. And had we accused him of lying, fraud, hiding the ball, and those sorts of things, I would agree with you. We would be in a different position here today. But that never occurred. And again, it was a very, very small part of the case. So with that, I think I'm starting to repeat myself, and I apologize
No, I've
to
got a
the court for
question
that.
for you. If you could, in terms of preservation, back on the request to produce issue, if you could comment with respect to Judge Kelsey's question about whether appellants objected procedurally as to the use. Was that argument preserved, or is that preserved?
I don't believe it was, and I believe with the way I read Judge Kelsey's questioning that it wasn't, because they never specifically mentioned that. They talked about mistrial and they shouldn't do that, but they never specifically mentioned it was a discovery issue. It shouldn't have been brought up. So I would agree with how I read Judge Kelsey's question, that it wasn't preserved and it shouldn't be an issue before this court for that reason as well. So I probably talked a lot longer than I should have, and thank you for Mr. Sprague for giving us both a couple extra minutes, but I appreciate the court's time. Thank you so much. And we ask that the court affirm this is an abuse of discretion standard, very high standard, as the court knows, and thank you.
Mr. Sprague, rebuttal?
Yes, Your Honor, I'm going to move quickly. First of all, Your Honor is right. In pages 806 and 807 of the transcript, our client was specifically asked, you were asked for these documents and you didn't produce them. And he was asked repeatedly. So it wasn't akin to just saying you don't have any documentation. He was specifically asked about discovery. Secondarily, the issue about not being explicitly accused of fraud is settled by the Rowland case. In the Rowland case, the questions were very akin to what was asked in this case. They were asked, for instance, who had access to the security camera systems, the characteristics of the system, what the South Lobby camera would have captured, why it wasn't downloaded, etc. Those were the questions asked. No allegations of fraud, and the court reversed, holding, considering there was no evidence that the South Lobby camera was missing because of spoliation or concealment, the pervasive inquiries by the Rowlands counsel into the security camera missing recording implied to the jury that the South Lobby recording was hidden or destroyed, as it would have been unfavorable to the defense. And that's exactly what they did in this case. We did not open the door into inquiries into a discovery issue. We agree that they could have asked questions like, how much do you continue to work? Substantive questions about his ability to continue to do his job. They could even have asked, you've provided this jury no documentation to support your claims that you're working less. That's not what they asked. What they asked was, you were asked for this during discovery and you didn't produce it. And that puts us under Rowland. The defense has cited no cases to the contrary. The defense is simply wrong about what the proffer argument went to and what the proffer was for. There were numerous sidebars about work order, Jamie Cruz, and Paul Thaxton and the policies. At the end of that whole colloquy back and forth, there was a suggestion that a proffer be made, which the court said, stop wasting my time. So it went to all three issues, which deprives this court from the ability to consider any of them. As to the argument that we didn't ask for the proffer, they did, this court's O'Shea opinion, among others, that we cite says that we are excused from asking for a proffer if it would have been useless ceremony, or if the court had indicated that such an offer would have been unavailing. And that's
Thank
it.
you, Mr. Sprague. I believe you're out of time. Thank you both. It was well presented on both sides. If counsel for our next case would let them vacate before you move forward, that would be appreciated.
Thank you. Great day. Thank you.
All right, counsel would come forward. Our next case, our second case on the calendar is Invo Incorporated versus Ring Power Corporation. And as the court understands it, 15 minutes per side. Mr. Vader, did I say that correctly? Vater. Thank you, Mr. Vater. Are you prepared to proceed?
Yes.
How much time, if any, would you like for rebuttal?
I'd like to reserve 5 minutes for rebuttal.
All right, 5 minutes. When you're ready, please proceed.
May it please the court, my name is Michael Vater of the Ticton Law Group, and I'm here on behalf of the appellant, Invo Inc. There are 3 issues that are raised in the briefing, and I'd like to focus on the spoliation issue first, because that was the fundamental jury instruction which affected this particular case. In this particular case, there was a fire involving a bus on the compound of my client.
What happened to the bus?
The bus caught fire.
Well, no. What happened to cause it not to be available to be part of this trial?
Sure. So what happened was the representatives from the defense came on site, they inspected the bus, and then the bus sat for a period of 3, 4, 5, 6 weeks until in May of 2018, a few months later after the mid-March fire, the bus was then transferred to the insurance company who was representing my client. So the bus was sitting there for many weeks after this inspection occurred. Hundreds of photographs were taken of the bus, and that was very similar to what some of the sister appellate courts found, especially in the 2004 Fourth District Court of Appeal case, the Royal.
Well, Mr. Potter, let me just ask you this. Isn't the essence of the claim, the bus? So didn't you need that bus to make the claim?
We didn't need the bus to make the claim because the inspections had already occurred. Weeks had gone by before there had been any type of correspondence. No correspondence whatsoever had been received from the defense saying we need this bus to remain for additional testing, additional observation, additional review. The bus had remained on site for weeks. It was a burned out bus. It would have caused environmental issues, et cetera, if the bus had just remained there for months, years. How long is it supposed to remain on site? Indefinitely?
Well, no, and the court gets to ask the questions today, Mr. Votter. Thank you. But the question this judge has is, I'm just, again, having difficulty understanding how you advance a case on behalf of your client when the very essence of that case is the bus. And so here we know the bus was not part of the trial, correct?
Correct.
And at some point before the trial, it was destroyed?
The bus was not destroyed. It was, the possession of it was simply transferred to the insurance company.
And so that was argued to the court?
It was argued and it was reflected. One of the great things is that this court has the benefit of the extensive orders that were entered by the trial
Well,
court.
and that wasn't the court's question. Is it reflected in the transcript that that argument was made to the court?
It's reflected in the order which reflected the testimony presented to the court. And that's where that argument was presented, Your Honor.
And after evaluating all of that, the court determined to give the instruction the court gave, correct?
It did.
But we do not have a transcript of that colloquy that led to the order?
No, we relied upon the order itself because our position is that the order accurately reflects what was argued and presented, what evidence was presented to the trial court.
So we're bound by the four corners of what the court said, correct?
Yes, we're bound by the findings of the court as well as the conclusions that were reached by the court.
So obviously you don't take exception with the findings of the court?
No, we don't take exception with the findings, but the findings of the court is what mandates the reversal because the actions in this particular case was not a situation of willful destroying of evidence to try to hinder the defendant in this case, nor was it a situation where someone was being negligent and spoiling evidence. It was simply a transfer of possession after weeks had gone by, over months had gone by, before the bus had transferred to the insurance company. That was the first issue. The second issue that is the one that deals with...
Before we leave that question, this is a very specific fact question, and if you need to supplement later with a record site, that's fine. But you say on page 11 of your brief that the bus was only disposed of after the bus company received written permission from its insurance agent who had obtained such permission directly from the repair shop. Okay. There's no record site to that, and I could not find, I did a word search, and there's not a single reference to permission among the 256 times it occurs in the record in connection with permission from the insurance agent. There's no reference to insurance agent that's relevant. Can you back that up? Did the insurance agent get permission from the repair company to dispose of the bus?
Yes, and I'll have to find where that is in the record.
That's fair. You feel free to file something on that.
How about a month and year that occurred, that apparently this permission, or I guess what month and year was the bus sent to the insurance company?
It was sent in May of 2018.
All right, that was a year before suit was filed, the initial complaint was filed against Ring Power.
Yes.
So knowing there was a potential for an upcoming lawsuit to be filed, there was no burden on your part to preserve that critical evidence?
I did not see it because in the case law, in the Royal v. Alliance case, the Fourth District Court of Appeal in 2004 said there's no duty even when litigation is anticipated. So, and even the Second District Court of Appeal in Landry said that spoliation does not automatically lead to a sanction. There was nothing sanctionable that should have resulted as a result of the conduct.
Well, I think Judge Thomas's question is a little different. Your client knew a lawsuit was coming, correct?
There could have been potentially a lawsuit if it was unable to be resolved between the parties, absolutely.
So given that dynamic, it seems to me the court could reasonably find that knowing a lawsuit is coming and knowing the corpus of the lawsuit is the bus, that the fact that the bus is not there anymore is enough for at least some sort of presumption related to spoliation. Why is that wrong?
It's wrong, Your Honor, because of the fact that the critical issue was the defense had the opportunity to inspect the bus before it was disposed of, and they actually did come on site and dispose of the bus.
And I saw that. And you got their permission to get rid of it?
The permission was given from Ring Power's representative to my client's insurance representative to then my client to to transfer the bus to the insurance company. It wasn't as though there was no evidence in the record to show that there had been a subsequent, after the inspection, some sort of efforts made by the defendant to come out and do further inspections or testing or photographing of the bus itself.
But you concede that inspection occurred almost a year before a complaint was filed, so they had no idea what causes of action were or were not going to be raised. So it's a blind inspection.
Well, the evidence in the record shows that that hundreds of photographs were taken. There was an inspection related to a fire on the bus, and that's what the record demonstrates. I would like to just briefly discuss a few of the other issues, one of which is the granting of summary judgment. It was improper for the court to grant summary judgment when there was an issue as to the credibility of the witnesses. The Vega case that was recent, that opinion, which was issued by the Third District Court of Appeal last year, really highlights that when there is a credibility issue.
Well, and this court understands, I think all three judges understand, credibility is not a summary judgment issue. But the only thing I see on the negligence issue is this email. And it candidly begs the question of whether it establishes a breach or causation. So explain to me how this email, even assuming it was admissible, and that's seems to me another hurdle you've got to overcome, but assuming it was admissible summary judgment evidence, how did this cryptic email establish a breach and causation?
The email establishes breach and causation because there's a reference in the email which says, based upon our conversation, the buses, et cetera, that specifically raises the issue of breach in terms of it being a potential issue in terms of the in this particular case, a future fire or future situation. And that little email itself, it was what was being put forward.
I've got it in front of me, Mr. Votter. I don't see that, but maybe show it to me.
My particular showing of the email demonstrates that this particular item was argued here in terms of the bus itself.
Well, I'll just read it. Many of these issues would be a fire and/or safety hazard if left unfixed, correct? We definitely want to prevent any breakdowns or harm to any of our customers. Thanks. And then Ms. Ferber, Mike, yes, you are correct. I'm having trouble divining a breach of the standard of care and/or causation with this case from that one email. So where is it?
It's in referring to the review of the buses, and it was set up in our client's affidavit that he had taken the buses to this Mr. Ferber's shop in terms of the review, and this was his review after seeing the buses, and that was that breach and causation. I do just want to briefly...
If we don't find that, the summary judgment was proper, correct?
Well,
if we don't find as a panel that there was a breach and causation component to that email, then summary judgment was proper on the negligence claim, correct?
No, because of it has to be taken in connection with the affidavit of our client, which is in support. Just briefly on the last issue, it was the court awarded for a 5-page motion 23.7 hours of time, a 12-page motion 36 hours of time, an 18-page motion 58.8 hours of time as a sanction. And under the Martin v. Centex Rooney case and the order from the court which found that the plaintiff's expert witness testified that those amounts were excessive, it was improper as well for the court to enter that particular order awarding that amount of fees for the work that was done.
Counsel, what's the standard of review on that issue?
The standard of review is a de novo review because it was an awarding of attorney's fees.
I mean, do we defer to the trial court's, expert-supported assessment, or?
To a certain extent, there is a deferral to the trial court, but there is also this, in terms of when there's clear duplication of efforts, as was reflected under the Tamano case from the 4th District Court of Appeal in 1993, it mandates a reversal. I see I'm into my rebuttal, so I'll pass.
All right.
Stop up with Thomas, I'm not touching it. Oh, the stop, okay, thank you, there we go. How many lawyers does it take to figure out a podium? Good afternoon, may it please the court. My name is Jordan Janoski for the Appellee Ring Power Corporation. I'd like to begin with Judge Kelsey's point that was just asked. The standard of review on the fee award claim is abuse of discretion, and that's from the Philip Morris USA Incorporated versus Jordan case. It's cited in our brief. It's from this court from this year. So I won't elaborate too much on that.
And we don't have a transcript, right?
And we don't have the transcript, Your Honor. Again, this is all well within the trial court's discretion. I don't want to spend too much time on it, but nitpicking individual motions is frankly the trial court's job. And again, you don't have the motion or the transcript, and in any event, it's within the judge's discretion. So if there are no further questions on the sanctions, I'm going to go back to the summary judgment, if that's okay. So I think there was a line of questioning about this Ed Ferber email. And I agree with the court that that email by itself doesn't say anything. It needs context. And the context that should have come with that email is the affidavit, or are the affidavits of Invo's principals, Joey Friedman and Michael Farzad. Neither of those affidavits provide any further elaboration that give you context for what that email is talking about. So there's not only do we not have causation or breach of a standard of care, we don't even have a confirmation that that email is talking about these buses that we're talking about in this lawsuit. I mean, that's how...
We don't have a timeline. Were they, I thought counsel indicated that they were after the accident, after the fire.
So I'm afraid I don't follow your question, Judge.
Was the email sent after the fire bus became the fire bus?
I believe it was, but my point is that the email itself doesn't reference any of these buses, and the affidavits don't tie that email to these particular buses. So I guess, yes, it's theoretically possible that the email was sent after the claims were raised, but there's nothing in this record tying Mr. Ferber's remarks to any particular bus that's at issue in this lawsuit. I can go further. We have the affidavit that Ring Power went and got from Mr. Ferber and used in its summary judgment evidence, in which he says, basically, that he doesn't know that Ring Power did anything wrong. He comes out and he squares that circle for us, right? He says, I'm not commenting on Ring Power's standard of care. So that's how we know for certain that Mr. Ferber can't create a summary judgment issue on the negligent repair case. So all the trial court has on summary judgment is Ring Power's expert shifting the burden, right, saying that Ring Power did nothing wrong, there's no breach of the standard of care. And then we don't have anything from Invo in terms of standard of care to meet the now flipped or now the shifted burden. So I think Judge Jay, you're right on the issue. There's nothing in this record that creates a fact issue on the negligence claim. Excuse me.
We heard a lot of talk about spoliation.
Yeah, we can.
What says your client on the spoliation argument?
So Invo's trying to relitigate factual issues that were decided below, right? The issue here, or the standard here, again, is abuse of discretion. And your honors are well aware the trial court's findings come clothed in the heavy presumption of correctness, right? That's the League of Women Voters case that's cited in our brief. Ring Power only needs to show that there's competent and substantial evidence to support the lower court's decision. And what the record here shows is that there's more than enough evidence to meet that task. Invo was told that the fire bus was evidence. That's from the order itself, which references Mr. Layson's testimony during the hearing, right? We don't have Mr. Layson's testimony in the record, but we have the judge's findings based on that record, and that's on page 3516 of the record. You'll see in the record somewhere that the bus was stamped, or not stamped, but had a taped with a placard saying in big bold letters, evidence, right? This may be evidence. You need to contact the person, I don't know if it was Mr. Layson or someone else, who put it there, right on the side of the bus. So there's no dispute here that Invo knew that this bus was a piece of evidence. There's no dispute that it was important to this case, and Invo should have understood that it was important to this case. There's no dispute that Invo voluntarily disposed of the bus by allowing its insurance company to take it, basically.
Let me ask you a question about the bus versus the site where the accident occurred. I think there was some witness referred to the possibility that seeing it in place would have been important. Was it impractical to just leave it sitting beside the side of the road or wherever for a year until the complaint was filed?
My understanding is that the site was Invo's lot, for lack of a better word.
Is that in the record?
I don't know if it's in your record
Yeah,
that that's an
fuzzy on what's
important
in there.
detail. What I will say is, today is the first I'm hearing of this suggestion that Ring Power as representatives authorized the bus to be disposed of. I'm not saying it didn't happen, but I have never heard that before. And so if there's going to be additional briefing, I'd certainly would like an opportunity to be heard on that issue. Invo disposed of the fire bus before it filed suit. It disposed of buses 1 and 2 before it raised its negligent repair claim. And so
What about their argument that you knew the vehicle identification numbers, you could find it somewhere and go look at it?
it's contradicted by the record in the lower court's findings, right? Judge Brasington said that the unrefuted evidence is that the buses are not available for Ring Power's experts to inspect after the suit. There's credible testimony in your record to support that finding, and so we're not in a position where we're litigating the entire case, right? We have Judge Brasington's findings, they're supported by the evidence, and so there's not a lot for this court to do on that issue. Counsel relies heavily on the Landry case. This is the odometer case where the car was repossessed. The biggest part of that case, or I guess there's two major components to that case that resulted in reversal. The first is that there was no evidentiary hearing before the sanctions were awarded, right? I think the sanction was actually dismissal of the case. And there was no finding, because there was no evidentiary hearing, that the evidence was unavailable to the defense. And this obviously is a completely different situation. We have two evidentiary hearings on the spoliation issue in this case, and we have the unrefuted testimony that the buses are unavailable, followed by the court's finding that the buses are unavailable. So Landry is not controlling or frankly even relevant in this case. The other component to Invo's argument is the suggestion that they didn't have a duty to preserve these buses, and that flatly is not what the case law says. The duty for litigants to preserve evidence triggers when a claim or litigation is reasonably foreseeable. That comes from League of Women Voters, which is cited in our brief, the Hediger case, which is cited in our brief, the Torres case that is cited in our brief. Frankly, I really don't think there's much dispute in the case law here. For a litigant, when litigation is foreseeable, that's when your duty is triggered. There's not, as far as I can tell, there doesn't seem to be a dispute that litigation was reasonably foreseeable to Invo. I don't think that on this record we could find a dispute there. So what we have are the cases that Invo cites, primarily the Royal and Sun Alliance case. And the distinguishing factor in that case is that that is a case about whether a third party has a duty to litigants to preserve evidence for them, right? In that case, a yacht caught fire after a repair company came in and did some work on it. Eventually, the subrogation insurer is suing the repair company, and they find out all the evidence is gone, and so they file a spoliation cause of action against the marina that held the property. And so the question was whether that marina owes the litigants a duty. I think in that case, the Fourth DCA found that there wasn't a duty. But the point is that that's a different question than what we have here about what duties litigants owe each other to preserve evidence. Counsel cite the Martino versus Walmart case, another Fourth DCA case. The issue in that case is a kind of a nuanced and tricky one, but also not relevant here. It's whether you can maintain a separate spoliation cause of action against your direct tortfeasor in addition to your negligence claim against them. So in that case, I think it was a shopping cart that was allegedly negligently maintained or repaired that injured a personal injury claimant, and he wanted to sue Walmart for the personal injury, the negligence, right, negligent maintenance of the cart, but he also wanted to sue them for spoliating the cart and getting rid of it. And so the Fourth DCA expressly sidestepped the issue of duty in that case. They say whether you have a duty to preserve in this circumstance or not, you don't have this cause of action. So again, I'm taking us kind of far afield because that's the case law that INVO is relying on. It's not on all fours with our facts here. We have a straightforward negligent or a spoliation claim here of a opposing party that has spoliated the key piece of evidence in the lawsuit. There are some other issues that are touched on in the briefing that I'd like to make sure I cover with my time. There's some suggestion that the court's various orders create some sort of risk of a double recovery. I just want to emphasize that I agree with counsel that a double recovery is not permitted under our law, but the orders that we have in this case are carefully worded to avoid that exact possibility. We expressly, our office drafted the orders. We made sure that this wasn't going to occur. We would never seek to have a double recovery in this case. It's just not a risk on these orders. And then the other issue I wanted to address briefly is the FMVRA summary judgment. I just want to emphasize again that counsel, or INVO, is attempting to rely on evidence that was not presented to the trial court on summary judgment. Right? We have this rule, again, bear in mind we're under the old rule. This was decided before the switch last year of the summary judgment rule. Under Rule 1.510C, a party is required to identify their summary judgment evidence with specificity, what they're going to rely on at the hearing on summary judgment. INVO did that. They provided the 4 affidavits that they relied on. That was their summary judgment evidence. They didn't cite to anything else. They didn't rely on anything else. That was their summary judgment evidence. When INVO lost on the FMVRA issue, they wanted to come back. They asked for reconsideration, and on reconsideration, they pointed to additional pieces of evidence that they had not relied on, but which were available to them on summary judgment. They wanted to get a second bite at the apple. And there's plenty of case law, that there's the rule itself, say you can't do that. Okay, so you can't point to these other documents and say these create a summary judgment issue. And of course, those same...
Counsel, let me ask you a question about the statutory claim.
Sure.
It appeared from my review of the evidence that they were happy to, pay the invoices even if there wasn't a written estimate or it went over a little bit. I mean, I do it. Is there a requirement under the statute that there be some sort of actual injury that they,
Damages are certainly a component of the statute. It's not as simple like you failed to give me an estimate, therefore pay, $100 or whatever. It's, you have to, if you've been damaged by a breach of the statute, then you have a civil cause of action. But I would say more importantly, we have the same issue with the 5 invoices that are identified in the briefing that we have with the Ed Ferber email from the negligence issue is these documents by themselves don't show a breach of the statute. They need context. They need someone saying, this is an invoice that I received that I don't have a corresponding written estimate for, and that's not in your record, right? And in fact, we have at least one of them. We have the pro forma invoice, the written estimate, in the record. The others, I don't know whether we have the pro formas for those in the record or not, but the point is the burden is on the plaintiff to show what these actually mean, because by themselves, they don't show a violation of the statute. And in fact, there's nothing in your record that shows a violation of the statute, and that's why summary judgment was granted, and that's frankly why the summary judgment should be affirmed, as should the other orders that are on appeal. And so if there are no further questions, I think that will be the end of my time. Thank you.
Rebuttal?
Thank you. I'd like to address a couple of the points that have been raised during the appellee's presentation. One, the statute under the Florida Motor Vehicle Repair Act states that the actual damage is the having to pay that invoice that was not, for which a written estimate was not provided. So there was no requirement to show additional injury or loss besides the having to pay that invoice that was presented in the affidavit itself, and that also came from the Fifth District Court of Appeal case Austin versus Morris from 1986. There's also the email for Mr. Ferber was, the record shows, was sent after the original fire bus. And the record also shows that there were only 3 buses that Invo had that owned. They only owned 3 buses. There was the one bus that caught fire, and there were the 2 other buses, which were subsequently examined by Mr. Ferber after the fire situation. That his email placed in context with the affidavits that were set forth did present sufficient record evidence under both the old standard of 1.510 as well as the revised standard of 1.510 to present a question to the jury where a jury could reasonably find in favor of the claim. So we would ask that this court reverse the order vacating or reverse the order entering final judgment as to those claims to allow those claims to be presented to the jury. And then the fundamental issue comes up in terms of the spoliation issue. And the facts are not refuted because the court put the order, the facts are properly placed in the order by Judge Brasington, which was that there was testimony presented at the evidentiary hearing by Invo's representative. There was testimony presented by Ring Power at the hearing. Here was the testimony, and the testimony really isn't so much in dispute in that there was a bus that caught fire. The inspectors came out within a few days later. There was an extensive multi-hour inspection related to the vehicle, and then ultimately the vehicle was transferred possession from Invo's lot. I think there was a question asked as to where it was located. It was on a lot that was, it wasn't along the road because the fire had actually happened while fortunately no passengers were on it. So ultimately we would ask this court to reverse the orders and remand for a new trial as to all counts in this particular case. Thank you for the court's time and opportunity to present today.
Thank you, counsel. We are in recess.
All rise.